Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Those are tough because they think they have that smoking gun. And when you have to deliver that bad news, it really just takes the wind out of their sail. But it's how you deliver it. And you don't want to come across and say, well, we can't use this because you obtained this illegally and you shouldn't have done this. It's more of, unfortunately, even though you are in possession of this and you have that knowledge, we can't use it because this is how it was obtained. And there is some reasonable expectation of privacy. Whether or not you agree with it, unfortunately, that's the law. And if we were to proceed forward with this, here's what we risk happening to your case. And hopefully at that time, they'll be a little bit more calmer and they'll be understanding as far as what those risks are. Now, that doesn't mean that we can't still pursue an affair, but we'd have to obtain it through the proper methods and channels. And that's when those discussions of here's what we can do, here's kind of what it's going to cost, and depending upon your jurisdiction, this is what the court may or may not rule on. And is it relevant to your particular case? And if it is, then it warrants further discussions. But if it's not, then it's one of those other tough conversations that we shouldn't really proceed this. Now, at the end of the day, it's the client's decision. If he or she wants to pursue it and it's in good faith, then I will. But I just want to make sure that they know kind of risk versus reward.
Exactly, right? They are the captain of the case. We just drive the ship. You kind of touched on it a little bit earlier about, understanding the reason that you want to prove adultery. There are jurisdictions and there are situations where there is no financial incentive to prove adultery whatsoever. And Dan talked a little bit about, what about children? So Rebecca, how do you handle when you want to show, what do you need to show to prove that the adultery is having a negative impact on the children?
Right. There has to be some sort of direct, in my experience, there has to be some sort of direct impact on the children. Just the fact that a consenting adult is engaging in some sort of unsavory behaviors, courts don't really care. They're like, please don't tell me anymore. I don't want to hear it. I don't want to know. But if there's some sort of risk to the child, I mean, if the spouse is having an affair with a known child abuser or child predator or something along those lines, of course, that's going to be impactful on the custody and visitation case. If the new paramour is a drug user, if the new paramour has, some sort of criminal history, they have weapons, there's some sort of reason independent of their relationship with the spouse why they could be considered something of a danger to the children, or their environment is a danger to the children. That's certainly going to be relevant, but you really have to be cautious in making those types of claims and really have something to substantiate it, because otherwise it just looks like jealousy, right? And we see this all the time, not even with folks that are necessarily married or never were married. When there's a new girlfriend, when there's a new boyfriend, when there's a new fiance or spouse that comes into the picture, frequently we see complaints about, we need to change custody or visitation because I don't like the new girlfriend. I don't like the new boyfriend, whatever it is. So the court sees this time and time again. They know that you don't like the new partner, but you have to show some sort of objective reason why the new partner presents some sort of a safety or health risk to the children. And sometimes it can just be dealt with by saying, new partner can't be around the kids. Okay, that doesn't restrict the other parent from engaging in a relationship with them. It just means they can't live together or be around the children, and they can work around that. So, you also have to think about what it is you're ultimately going for. You're probably not going to be able to cut this person off altogether.
That's right. Sometimes you're saying you have to draw this nexus between the children and the paramour, and sometimes we can't, right? I mean, sometimes the paramour is better than the other child's parent. I've seen that happen. Yeah. But in those situations, we can go to the court and say, look, we understand that these people are separating. We understand that these people are going to get divorced and that these people are going to be dating when they're divorced. However, while they're going through this divorce, it is not healthy. It's not in the best interest of the children to see these people living with somebody else, to have this confusion during all this. And we can kind of use that to create this separation between the child and the paramour. Are there any things like that that you use, Dan, for your clients?
Sure. And it's, you can really break that down. You have it during the actual litigation process to where, I mean, you're spot on that. What is that effect going to be for the children to see mom or dad was a significant other, especially when they're going through such a traumatic event as a divorce or just a legal separation. But then you also have it to where once the case is concluded, I've put into parenting plans that neither parent will introduce the children to a significant other after X amount of time. And that X is what is comfortable to both sides. Is it 3 months, 6 months, a year? It really depends. Now, at the same time, although it sounds great when you're fresh off of the divorce, it's like, yeah, let's do that. You want to advise the client, okay, it's going to be reciprocated. So once the dust settles and life goes on, and hopefully you're able to co-parent, do you want to be subjected to not introducing the kids to someone after a certain amount of time? So you want to make sure that you're advising them and hopefully having informed, reasoned decision making as far as if they want to implement that. And if so, then if the other parent violates it, then you have a potential contempt. So there are ways to restrict, but you just want to be smart about it.
Yeah, it's got to be mutually restrictive, right? And that is a hard thing to hear when the other side's got a paramour and you're fresh off a divorce. And you're like, well, I'm not going to date for years. And you're like, well, in my experience, you'll probably be dating soon. So, we've talked a lot about the client who has been aggrieved, the client who is the victim of adultery. So, Rebecca, how do you handle it when somebody comes in for a consultation or they come into your office and they say, look, I'm going to be honest with you. I'm the one doing the cheating. I've moved on. I need your help.
Right. So again, understanding what their goals are. What is it that they're looking for? Is there some financial reason why we need to try to defend against this adultery claim? Are they going to be seeking support or something along those lines? And then what kind of proof is out there? How do you know that they know, right? Was there a conversation? Could that conversation have been recorded? Did they get access to some photos? What was it that happened that sort of brought this all to a head? And so a lot of the time we might just want to try to negotiate an agreement if they know that there's something out there that they really don't want to get into a public setting. For example, I had a client who was a principal at a school and, she had been having an ongoing affair. We knew that there was certain evidence out there that looked pretty unfavorable. And we knew that the best course of action was let's try to just negotiate this and have something that's going to be reasonable for everybody. And that way there won't be this public record out there of you in these acts, right? So that could be the advice, really depending on what the client's goals are. We're also going to advise the same way we did in the reverse to say the burden is really high. What proof does the other side actually have? Do they just have some sort of feeling or inclination? Or do they actually have some sort of solid evidence that they could prove this in court? So that's another piece to get a handle on just right from the outset.
And Dan, same question to you. What is your advice in that situation?
These are always hard conversations to have with clients, but because they're coming to you at their most worst time in their lives, but they're so vulnerable right now, and they're admitting that they did something wrong, and they want to know what is my risk. So my first question would, how do you know that the other side knows? And if the client comes to me and says, I have had an affair, and the other side's aware because there's videos or pictures out there, I make sure that they do not destroy those, because that leads to spoliation of evidence, which a whole host of things that we've discussed as far as sanctions and striking pleadings and other potential issues. And so we want to make sure that those are preserved, but then what can we do to try to settle and negotiate? because it may be beneficial to the other side too. And I say that because I've had clients that are in the military, or they're in a profession to where if this gets out that they had an affair, then they could lose their job or be demoted. Or if they had an affair with a subordinate, then both of those could be subjected to termination or other types of corrective action. And it may not benefit the other side because they may not receive as much by way of finances. Now, with that being said, it depends on the jurisdiction too, because if that does happen, that could be considered a voluntary reduction in income. And so you want to make sure you're talking this through with your counsel to make sure that it sounds great. Let's try to settle because I don't want to be fired or terminated, but know that the risk could be in a particular jurisdiction, regardless of what happens, that court may consider that a voluntary reduction in income, and then the court can impute whatever you were earning back to you. So it's just that having that open dialogue with the client to know, okay, here's what you're advising me. And if the other side does know, what is that going to look like? But on the other side, I've had situations where a client does admit that they had an affair, but it's with, if we talk about someone has an alcohol problem or a drug problem or a questionable past, then at that time it's okay, there's children involved. We want to make sure that you're not with this person anymore. Because if you want to spend time and have that quality relation with your child or children, you're going to have to just break up or end ties with this person. And that's okay. That's not spoliation of evidence. A lot of clients are like, well, I'm stuck in this thing and I can't get out. And what do I do? And it's no, in that situation, yeah, definitely just terminate, because we can turn that into a positive. You realize what you did was wrong. You started really getting to know the person and determined that they weren't the best fit to be around your children. And so that's why you ended it. And there's just so many issues that come up with this. But then also, if there's kids, but there's no questionable actions on the other side or past, it's you're going out and having this affair. The other side is most likely going to say, well, he or she's gone at these times, and instead of spending time with the children, they're out with their paramour. And so you have to start flushing that out and dialing it back as far as if they're going to continue down that path.
Yeah, it's kind of a weird idea to start giving relationship advice, right? Like almost Dr. Phil-esque of, hey, I looked up your paramour. It turns out they have quite the record, and maybe you should break up. I'm going to play your parent for a second. Might not be a good idea to date somebody who just got out of federal prison for murder. Just saying. I want to stay with you, Dan, because you brought up an interesting idea of spoliation of evidence. And is there a point, let's say you have Ring cameras at your house and you've been having an affair in your house, and one day, oh crap, there's Ring cameras. What point would deleting the videos off that be spoliation of evidence versus, hey, I'm the only one, let's take it from an adverse. I'm the only one who has access to these cameras. They're my cameras. The other side would have to break into my account to get these cameras, so I have the right to delete it. Is there some balance there?
That's a tough question. And I say that because there's a lot of discretion with the courts. And in my experience, in the spoliation of evidence would be if there was an action pending or an action going to be pending, then that's where you have to preserve that evidence. And when I say discretion, what I'm referring to is the time frame. And where I'm licensed, there's really no definitive time frame as far as it has to be 6 months, 1 year. There's guidance and case law, right? But not actual statutory codified law that says it has to be by this certain date. And so that's where those discussions with the lawyer comes into play. Because if you're contemplating divorce or even legal separation, and you erase or just basically get rid of the evidence, that's problematic. But if you're not contemplating it, I still think that's problematic, because why all of a sudden do you want to erase that? Because there's something that that the other spouse could take that and then file themselves. So that's why it's always a good idea to advise the clients what the risk is. But I always err on the conservative side and not erase and not destroy.
I like the conservative approach too for not doing it. We had a case where the other side had basically laid out their affair on Instagram. And when we asked for the information in discovery appropriately, they went and deleted their Instagram account. And when you delete an Instagram account after 30 days, the information is gone. And we went to the court in a very weird move, got an emergency motion for discovery, which is not very common, under the spoliation of evidence argument for the guy to have to turn it over. Well, through all of our discovery, we never got the information because the guy deleted it. The guy refused to turn it over. The court really couldn't go out and grab it off the internet. We didn't have the proper subpoena power to Instagram because it wasn't a criminal case. But it turns out the attorney had advised him to delete his Instagram account in an email, and we got that email. And so we were allowed, the attorney got sanctioned, but more importantly, adultery was proven. That was the remedy, but from the court saying, look, I 100% know that adultery happened, done. So even though we never actually got the statements, we got the ultimate goal of being able to prove that adultery happened because we had an email where the attorney had advised the client to delete this stuff. So Rebecca, how do you handle situations like that where clients come to you and say, look, I've got this bad evidence. Should I delete it? Should I not?
Yeah. So I was recently reading an ethics opinion where, a client had done her own digging, brought in all this information to her attorneys, and they asked, where did it come from? How did you get it? And they basically told her, we can't use this because of how you obtained it. And so take it back. We don't want it. But they ended up getting penalized. They ended up getting sanctioned by the bar, adamant enough, or they weren't strong enough in telling her, don't do this again. And then they sort of inferred that some of the information was used later on. Yeah. So the attorneys, when they went to prepare for depositions, they asked about certain dates and certain locations and certain other things that they would have learned about through this ill-gotten evidence. And so the court said, basically, you indirectly used it, even though you didn't bring in, whatever the evidence was. And you told the client, we can't use this, get it out of here. You didn't do it strong enough, and you sort of mentally still used it anyway. So attorneys really have to walk a very, very fine line when it comes to any of this type of information. So, before I put my eyes on anything, I want to know, where did you get it? How did you get it? What is it? Don't show it to me until all of these questions are answered, because I don't even want the inference that, I've somehow seen something that now I'm mentally using later on and could be penalized for. So this is going to be a really tricky fine line for attorneys to navigate moving forward on some of these decisions.
It is. And I have a lot of opinions on that particular ethics decision for several reasons. But, when you're advising a client who has done something wrong, it really is hard not to really kick in and say, look, the other side doesn't know about it yet. Let's delete everything. Let's do this. Cancel all your social media accounts. Cancel this, cancel that, cancel that. But it's good to understand that the remedy that all courts share is to say, you know what? We think you acted nefariously. We can't get the information, but we know you wouldn't have deleted it unless there was something there. So I can draw a negative inference from it. And that is something just passed in Virginia. We're used to, because it was a crime, you could plead the fifth on adultery. Now, if you plead the fifth, the court can take a negative inference from you pleading the fifth. So it becomes, from a client's perspective, having your attorney tell you, look, man, you've got to leave your Instagram live account, your account live, but stop doing what you're doing. Please stop doing what you're doing. It feels weird, but that's the advice that we have to give you. Or maybe you delete it and now the court says you cheated on them, but there wasn't enough there to begin with. That had the other side just gotten it, where you write all these flirtatious messages back and forth, there wasn't actually enough. It just shows that you were flirting online. And that's why when you're looking at evidence that makes you look bad, it's so important to look at that evidence. And it's so important for us to understand your goals of where you're coming from and understanding what you want from all this. So Dan, when you have a client that has done something, how do you talk to them frankly about, look, man, you don't want to go to court. Trust me.
Sure. It depends on what that information is and what that potential issue could result in. Meaning, if they're coming to me and they had the affair, but their spouse doesn't know it, and they're going to find out through discovery or depositions or whatever mode that they use, then yes, let's try to settle, because we don't have to tell them about it. If we're asked, we definitely will have to admit, because we don't want to be dishonest to the court. But if we can try to prevent a lot of this from coming out, it's going to be very beneficial, because we don't have to worry about trial expenses, preparing for trial. and then everything that comes before that's like depositions and discovery. So we can try to resolve it, maybe even a little bit more favorable to the other side, then that's going to be a win. But at the same time, there are situations that I've had to where a client came in, they had an affair, their spouse was aware of it, they tried to work it out, but the marriage didn't move forward in the way that they wanted to. And now they're concerned that that affair is going to have a negative effect. It may not. And why I say that is because in North Carolina, if you have an affair, but the others, you have a relationship back with your spouse and they're aware that you had the affair, then that could be considered forgiveness. And so then it's as if it never happened. So there may not be any risk or concern. So you want to, as much as you don't want to dig in and play that Dr. Phil part and ask them questions that they may not think have any relevancy to their case, you're just trying to get the dirty laundry. You want to dig in and ask more prudent questions on the affair, as far as timing, what happened afterwards, and what is the relationship like with their spouse now.
It is interesting sometimes when you're talking to people and you say, hey, I had an affair, my spouse knows about it. And the next question I ask is, when was the last time you had marital relations with your spouse? Right? Virginia's the same way. If you find out about the affair and then have marital relations with your spouse, it is considered forgiven. It's done. There's also a statute of limitations to adultery in Virginia. These type of issues like adultery are always so bad for people to go through. Even if you're the one committing the adultery, it's still usually very hard for people to go through this process. And working with an attorney that not only questions what's going on, but what your ultimate goals are is so important, right? Sometimes the cathartic effect to stand in court and say, look, they cheated on me. Why are we going to do that? What are you going to gain? And sometimes it's, hey, I cheated on them, but I'm going to take this to the mat. I'm going to fight it. Why? What are you trying to gain? And having a partner that truly pushes back against you and says, what do you want? Playing devil's advocate with you is about the best thing that you can have in a relationship with your attorney. So if you or somebody is going through divorce and you're really looking for that partner that you can trust moving forward, give Malone Hatley a call and see the difference that we can make for you. Thank you.
Thank you for tuning in to our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.